माननीय सुप्रीम कोर्ट में चल रही इस बड़ी सुनवाई के दौरान आज कोर्ट रूम में संजय राउत भी खुद मौजूद थे। सुनवाई के बाद राउत ने अपना पक्ष रखते हुए दावा किया कि कपिल सिब्बल की दलीलों ने उनके विरोधियों के तर्कों का कड़ा जवाब दिया है। माननीय अदालत भी इस पूरे मामले के हर कानूनी और संवैधानिक पहलू को बहुत बारीकी से देख रही है। कल बुधवार को भी इस मामले पर तीखी कानूनी बहस जारी रहेगी, जिस पर पूरे देश की नजरें टिकी हुई हैं। आगे बढ़ने से पहले आपको बता दें कि यह वीडियो केवल शैक्षणिक और सूचनात्मक उद्देश्यों के लिए बनाया गया है, ताकि आप इस कानूनी मामले को निष्पक्षता से समझ सकें। हमारा उद्देश्य माननीय अदालत की कार्यवाही का केवल तथ्यात्मक विवरण देना है। अब इस पूरे कानूनी मामले पर आपकी क्या राय है? आपको क्या लगता है कि इस संवैधानिक बहस का क्या परिणाम हो सकता है? अपनी राय कमेंट बॉक्स में जरूर लिखिए।
Let me apologize to your lordship, Malad. I plead guilty, Malad.
No, it's all right.
I thought, Malad, because there were some matters already there, so I thought I was on my legs in court.
So what happened before lunch, we announced that we will take up the part of the matter.
Oh, I see. No,
We were unaware, Malad. Sorry, Malad.
Then we thought immediately we called because
No, I'm sorry.
we will not spare us.
I deeply apologize.
You were not here.
But I was just marveling. I was marveling at the level of patience you have.
It's all right.
Well, that's what I'm going to do.
So now we could spend.
I'm sorry, Malad.
It's all right.
Now, Malad, kindly see, I've now, Malad, finished with the list of dates. Let me start with the propositions and my written submissions. Your lordships will have that.
Completion.
Yeah?
We are almost near to completion of argument.
On the list of dates, Malad. Now I'll come to the issues.
During list of dates, legal issues have also been raised.
No, Malad. No, in fact, very, very serious issues that arise in the interpretation of 29.
But we are.
No, I know that. Your lordship never does that. But I will also never, Malad, take time which is unnecessary. We've never done that, Malad. That's not part of our, learning that. Malad, we just hand over our written submissions. I'll deal with the Election Commission first, Malad. So I'll deal with the other issue, Malad, of...
Not on the argument.
Yes, just the arguments and the relevant pages, Malad, so that I can take your lordships.
Fine.
So, Malad, the impugned judgment dated 17/2/23. This is Que, Malad's para 15 of the symbols order. Is in 4 material parts, Malad. Determination that a split has occurred in the Shiv Sena is set out in paras 58 to 70. And, Malad, page 485 to 492. Determination that the test of the party constitution is not appropriate to decide the disputes in these paragraphs. Determination that the appropriate test is the test of majority, but the consideration of majority in the organizational wing does not lead to a satisfactory outcome is in those paragraphs. And determination that majority in the legislative wing is decisive in awarding the party symbol to the respondents is in these paragraphs. Now, let me go to the first paragraph, Malad. That is, determination that a split has occurred in the Shiv Sena. Kindly come to paragraph 58.
Fifty-eight of the impugned judgment.
Yes. That's in the compilation, Malad. Convenience compilation. Page 485.
Page number, Mr.
485. Malad. Paragraph 58 at 485. Must you read that?
Yes, whether a split has occurred.
Yes, exactly. That's the first part. So the petitioner in his petition dated 19/7 has submitted that a split had occurred in the Shiv Sena whereby two groups, one led by him and the other by the respondent, had emerged. Petitioner had relied on the fact of political alignment and alliance with political parties of different ideologies as the reason for the emergence of such split, He further submitted that a majority of the members of the legislative and organizational wing of the Shiv Sena were supporting the petitioner. On behalf of the respondent, it was fervently argued that the petition only indicated a possible split in the Shiv Sena legislative party and not the party itself, and that political realignment could not be a ground for split in the party. It further argued that there should be a vertical split in the party and that such split should not be of evolving nature, but rather should have occurred at a particular point in time. With regard to the issue of political alignment of party, it is submitted that the same is of no relevance for the Commission to decide a dispute for the purpose of 15. However, emergence of a separate group or rival faction in the party, which is the result of any political alignment, either solely or in combination with other factors, depending on the facts of the case, can be essential for the Commission to decide about existence of a split. So it says in the present case, there are other factors which indicated that a split in the Shiv Sena. The indicator of the emergence of a split in Shiv Sena was the holding, now this is the most important, was the holding of a separate meeting of the legislative party. So your lordship knows, Mullahs, that can never amount to a split in the party. As per the petitioner, a meeting was held by a group supporting respondent 24 to 55 MLAs of the SSLP, that is the Shinde group, attending the meeting and passed a resolution for removing the petitioner as leader of SSLP, whereas at the meeting held by the petitioner, 34 to 55 MLAs of SSLP attended the meeting and reaffirmed their faith in the petitioner as leader of SSLP. It is also pertinent to mention that both the groups appointed their own leaders as well as chief whips of so-and-so. Both the groups also initiated disqualification proceedings against MLAs who were supporting the other group under Rule 6 of the Maharashtra Legislative Assembly disqualification rule. Similarly, both the groups appointed their own supporters as leader of the Shiv Sena party. So, Malas, that's point number one. That is the 21st June letter. Your lordships will remember the 21st June letter only relates to the legislative wing. Malas, that is the 31 MLAs at that point in time, right? And the commission says that amounts to a split in the party. Contrary, Malas, to para 15, contrary, Malas, to the judgment of this court. Now, Malas, kindly see another part. So this is one fact. Another pertinent fact was that the letter of 25/6 received by the commission from Anil Desai, wherein it was mentioned that the petitioner and some MLAs under his leadership were indulging in anti-party activities, and that it was suspected that the delinquent MLAs tried to establish a new political party using the name Shiv Sena or Bala Saheb. The extract of the said letter is reproduced below. I don't have to read it. And then 62. Subsequently, the commission also received 3 separate letters dated 1st July from Anil Desai, wherein it was stated that Eknath Shinde, Tanji Sawant, Uday Samant, Gulab Rao Patil had indulged in anti-party activity and have voluntarily given up membership of the Shiv Sena. In the said letters, it was further mentioned that the said persons had been removed from their respective position in the Shiv Sena, set up by Shiv Sena Paksh Pramukh, respondent under the provisions of the party constitution. This commission is of the view that the aforesaid letters were further evident of emergence of a rival group in the Shiv Sena. So what's the conclusion? So, therefore, he says these 3 communications, 21st June, which I read to your lordship, 25th June that I read to your lordship, 1st July that I read to your lordships, he says amounts to a split in the party. Now, if that is the logic, then he can't assume jurisdiction because a split in the legislative party can never be a split in the party.
Figure 63 first line.
I'm coming, The next point to be
That is how it comes to the party.
I'm coming, The next.
Since there is a split in the legislative party, we'll infer the split in
How can you do that?
consequential.
That's the problem. That's my argument.
I-
That's precisely the point.
That whether a split of the legislative party
Can never be a split in the.
by itself of a split.
That's correct. And he relies on these 3 documents, 21st June, 25th June, and 1st July, which I've read. So, if it doesn't amount to a split, he can't assume jurisdiction. My argument is, he assumes jurisdiction on the basis of these 3 documents. If these 3 documents are not evidence of a split in the party, he can't get jurisdiction under paragraph 15. Because jurisdiction under paragraph 15 only comes when there is a split in the party and then two rival groups emerge. So that's my first submission on the first point. Now come to the second one, para 63. The next point to be considered is whether a split in the legislative wing of the party results in the split in the party. But that's what he's already said. It is stated that under paragraph 15 of the symbols order, the commission adjudicates a dispute when rival groups emerge in a recognized political party. The recognition is dependent upon electoral performance of the concerned political party, as explained in CA and CB. Well, 6A and 6B results say that whether you're going to be national party or a state party, that depends on the percentage of votes that you get. As your lordship knows, that's the standard test. That doesn't apply in this case. That's of no relevance. Thus, the aforesaid provisions indicate that the electoral performance of a political party is not only essential for getting recognition under the symbols order, but also for its continued recognition in view of the said legal position. This commission is of the view that for any dispute involving a recognized political party, where the dispute primarily revolves around the claim over the recognized symbol of the concerned political party, the legislative wing of the party cannot be viewed in isolation. What's the logic of that? There is no doubt that it is the organizational structure of the party, including the grassroots workers who toil and labor. This is all irrelevant, according to me, Mullahs. Who toil and labor and turn an association of individuals into an electoral machinery, which then contests an election, and the resultant fruit is the popular vote received by it. The final product of the whole cycle is the election of legislators, such as members of parliament, but we need not go into that. Now I kindly come to it is also apposite to mention that most often members of the legislative wing are also part of the organizational wing, no doubt about it, of the party. In the present case, the petitioner is a member of the Legislative Assembly, was also a Shiv Sena leader, part of the organizational structure of Shiv Sena before the dispute arose. Similarly, the respondent, who is a member of the Legislative Council, served as Shiv Sena Paksh Pramukh, the position which is the very apex of the organizational structure of Shiv Sena. If the 2018 constitution of the party is seen, now he relies upon the 2018 constitution, which he doesn't look at later. So now, Malaz, he deals with dispute case number 1. I already, Malaz, have already made my point on this, that this doesn't apply at all. This is in my favor. This decision is in my favor. Judgments note there has to be a split in the party. Your Lordship, I indicated that, Your Lordship. This judgment itself says there has to be a split in the party.
There are 3 decisions cited.
Yes, but the 2 decisions in my favor. The third one, Malaz, he distinguishes, and then dispute number 1 of 1994, which he relies upon, is completely inconsistent with what the judgment says, which Your Lordships haven't read, which I'll show to Your Lordships. So, Malaz, this is one judgment. Then he comes to Indira Gandhi and Brahmanand Reddy. There also proceeded on a split in the party. This judgment also doesn't apply, and he relies upon. Then dispute number 1 of 2017, Samajwadi Party, also, Malaz, split. That's between Akhilesh and Mulayam Singh Yadav. That was a split in the party. So, Malaz, he refers to these 3 judgments. All of them talk about split in the party, not in the legislative wing. Then, Malaz, what he does, he concludes, in view of the aforesaid facts, para 70, Malaz. So then I'd have done with the first submission.
Answer is in para 6 of the submissions.
Yes, kindly see, in view of the aforesaid, the commission is of the view that a split has not only occurred in the legislative wing of the Shiv Sena, but the party itself. Where did he get it from? He relies on the decisions which talk about split. So now he assumes, Malaz. So this is now my conclusion on that is in paragraph 6 of my submission. Just have a look at that.
Page 2.
Page 2.
Today's submission.
Yes, my submissions, today's submission, paragraph 6. So what I'm doing is I'm referring to the order and then the submission. It's easier for your lordships too. It is respectfully, I'm sorry, para 6, it is page 2, Malaz. It's respectfully submitted that this interpretation of the commission is contrary to a plain reading of para 15 of the symbols order itself, which require that there must be rival groups in the political party. It says when the commission is satisfied on information in its possession that there are rival sections or groups of a recognized political party, each of whom claims to be that party, the commission may, after taking into account all the available facts and circumstances of the case and hearing such representatives of the section or groups of other persons as desired to be heard, decide that one such rival section or group or none of such rival sections or groups is that recognized political party, and the decision of the commission shall be binding. It's on the assumption that there is a rival section of groups in a recognized political party, which he says is because the legislative party split. Therefore, I recognize that as a split in the political party because one of them held also a post in the political party. That's the logic, right? Now, kindly, let's come to para 7 of these submissions. The emergence of rival factions in the legislative party cannot in law lead to an inference that there are rival groups in the political party itself. To hold otherwise would amount to conflating the legislative party with the political party, Justice Chandrachud's Muller's order, which would be in the teeth of law laid down in Subhash Desai to the effect that the legislative party and political party are distinct and separate. In the judgment compilation, which your lordships will find, compilation final, yes, which I gave last time to your lordships, and
Page 69.
page 69, Malats. Yes. Yes.
Yes. The very first judgment.
Yes.
Yes.
Power to appoint a whip and the leader of the political party and legislative party are distinguished from concept. At page 69. And the judge says that, Malats, he defines legislative party in relation to a member and political party, original as the political party to which the member belongs. And then the court, Malats, comes to the conclusion. I'll give the conclusion at para 109. The political party and the legislative party cannot be conflated. The contention of the respondents that political party and legislative party are inextricably intertwined is erroneous for the following reasons. And I read para 109.1 and 2. Parliament in its constituent capacity was conscious of the necessity of not allowing anti-defection laws to stifle intra-party dissent and the freedom of expression of legislators. It was with the objective and the defenses of merger and split, which were later omitted, were introduced. The 10th schedule confers legitimacy to the actions of the legislators, which would otherwise lead to disqualification of a substantial number of legislators, 2/3 in the case of a merger, 1/3 in the case of the erstwhile provision for a split, disagree with the political party. The 10th schedule recognized the independent existence of the legislative party to the limited extent of presenting a defense to the actions of the legislators, which would otherwise have amounted to defection. So when Mullah, I file a disqualification, he can, in his defense, say, I have 1/3, and in the case of merger, I have 2/3. 1/3 is gone, 2/3 remains in the case of merger. Section 29A, Mullah, this is important, of the RPA requires an association of individuals called itself a political party to be registered with the ECI. The party need not have returned candidates to the assembly to be registered as a political party. Under the symbols order, a political party receives recognition as a state party or a national party. That's 6A and 6B, Mullah. Based on the total number of candidates returned to the assembly by the political party and or the total percentage of votes secured in the election. The purpose of requirement under the symbols order is to identify whether the political party has a substantial presence in the electoral fray to freeze the electoral symbol for the party. Symbols order does not refer to an association of legislators, deors the political party. Under the 10th schedule, it recognizes the legislature and the political party. The reference to provisions of the symbol order to argue that the concept of political party and legislative party are intertwined does not hold merit because the concept of the legislative party is not recognized in the symbol order. In fact, the symbol order doesn't talk of the legislative party.
Demolishes the reasoning of the.
So it demolishes the reasoning of the Election Commission straight away, Malaj. And this is a Constitution bench judgment. So, Malaj, that's on the first part. Then para 8, Malaj. In fact, the erstwhile para 3 of the 10th schedule, now this is important, contained a similar requirement in para 15, where a member of a house makes a claim that he or any other member of the legislative party constitutes the group representing a faction which has arisen as a result of a split in the original political party. And such group consists of not less than 1/3 of the members of such party. So, again, the same concept. The split must occur in the original political party. Then, 1/3 of the legislators can take a defense. Right, Malaj? Now, that argument was made in Rana, Malaj, which is the court case cited, Malaj, in para 9. And para 38 says of Rana, acceptance of the argument that the legislators are wearing two hats, one as members of the original political party and the other as members of the legislature, and it would be sufficient to show that 1/3 of the legislators have formed a separate group to infer a split or to postulate a split in the original political party would militate against the specific terms of para 3. So there you are, Malaj. Exactly what the commission has done, Malaj. Prohibited both under paragraph 3 and otherwise prohibited because of Subhash's judgment, Malaj. That paragraph speaks of two requirements. One, a split in the party, and two, a group comprising of 1/3 of the legislators separating from the legislative party. By acceding to the two-hat theory, one of the limbs of para 3 would be made redundant or ocious. Such an interpretation is not warranted by the context. It is also not permissible to assume that Parliament has used words that are redundant or meaningless. We therefore overrule the plea that a split in the original political party need not separately be established if a split in the legislative party. The same logic, Malaj, with the greatest respect, would apply. Now, Malaj, the Honorable Election Commission, in the impugned judgment, has erroneously placed reliance on two judgments to arrive at its finding regarding split in the political party, based on a split in the legislative party. However, both the judgments do not support the proposition. In both cases, split in the original party was categorically noted. It says both parties claim to have majority support in the State Steering Committee, and the Commission categorically found that a split in the organizational wing of the party has occurred. So that's the first judgment he relies upon. The second is Samajwadi. Both parties claim to be the president of the party. Commission arrived at a clear finding that there were clear manifestations of a split having been formalized on that day. Therefore, the impugned judgment, insofar as it assumes jurisdiction under para 15 of the symbols order on the basis of a split merely in the legislative wing, is unlawful and liable to be set aside. If I am right in my submission, Malaj, then the assumption of jurisdiction by the Commission to decide this matter is erroneous. And therefore, everything else that follows, Malaj, is illegal. So, Malaj, now we go to proposition B, right? Kindly come to B at page 1 of my submissions. No, I have to read this now. Page 1, right? Yes. The second part, determination that the test of the party constitution is not appropriate to decide the dispute. This is his next, Malaj, finding. Sorry?
Which part are you reading of?
Pair 1B, Malaj, 1B. Para 1B of the submission that I've given. Determination that the test of the party constitution is not appropriate to decide the dispute, Malaj, that is set out in paragraph 75 to 95, page 493 of the under test of the party constitution. Page 493.
Yes, test of the party constitution.
That's right. That's the second one. So, Mullah, he said, para 75, my lords, make quickly. Next, both sides moved to the test of the party constitution. The petitioner argued that the test of the constitution of the party could not be relied on in the present case, since the constitution of Shiv Sena is amended in the year 2018, was undemocratic. Mullah, this is very important. Now, the other side has argued, having been appointed under the 2018 constitution, and I'll give you judgment after judgment, both of the commission and otherwise, which says that if you have got the benefit of the very constitution under which you were appointed or elected, you cannot challenge that constitution. This is the first time the petitioner takes this position that it is undemocratic. Then whereas every benefit he had under the party was undemocratic. Then his election to the legislature was undemocratic. His being a minister was undemocratic. And which subverted inner party democracy. Never raised the voice, Mullahs, right from 2018. Never raised the voice. It was opportunistic and convenient to do so. The learned senior counsel submitted that the original constitution of Shiv Sena was amended in the year 1999 after the commission had written to Uddhav Thackeray and the then president of Shiv Sena to amend the constitution to make it more democratic. However, the changes introduced by Uddhav Thackeray were reversed by the respondent in the year 2018 by making amendments in the party constitution, which gave the power of appointment of most of the party office bearers to the party president. But let's just note the fact office bearers. And I'll come to that a little later.
The party constitution.
The party president. The party constitution as amended in 18 will yield non-democratic and biased outcomes as its design was changed to curb inter-party democracy and to stifle dissent. Further, it was contended that the said amendment of 2018 was in the teeth of the prevailing instructions of the ECI. Therefore, reliance on such a party constitution was untenable for deciding the present dispute. So the argument was, because it's undemocratic, I may have got the benefit of it, but you can't look at the constitution to decide this dispute. On behalf of so-and-so, it was argued that a rival faction or group emerging within a political party and claiming to be that party under 15 must do so within the framework of the party constitution. Well, how does he move the commission outside the party constitution? He wants the party, this very party, under this constitution. But was in fact appointed by the respondent in exercise of the latter's power provided under the party constitution as the leader of Shiv Sena, and that the petitioner then did not raise any grievance about the party constitution. Moreover, it was submitted that the commission must only consider the constitution of the party which is on record with it, and which was in existence at the time of arising a dispute between rival factions or groups of the party, and therefore in the present case, the petitioner was not acting as per the party constitution, which was on the record of the commission. Shri so-and-so further argued on behalf of the respondent that he enjoys an overwhelming majority in the rank and file of the party, and as per the members who were part of the Pratinidhi Sabha pursuant to the organizational elections in 2018, that the organizational majority test is the test to be applied in the present case, as was done by the commission in KP Unnikrishnan. To substantiate this argument, it was submitted that the petitioner had conducted meetings of the Pratinidhi Sabha, which is all undemocratic, he says, as well as of the Rashtriya Karyakarani, and that he had assumed the position of Mukhya Neta under which constitution? There is no Mukhya Neta under the 1999 constitution. So under which constitution did he, Maharaj, confer himself this title? I was Paksh Pramukh. He says, no, you are not Paksh Pramukh, or even if you are, we throw you out. I am the Mukhya Neta, and I transfer your powers to myself. Under which constitution did he transfer those powers? Not under the 99.
After the defection.
And this is after defection. All this is after defection. 2018 amendment of the party constitution being referred to by both sides needs to be contextualized. This is now what the commission is saying. Shiv Sena party was formed in the year 69. When in 89, section 29A was incorporated in the RPA, the commission facilitated its registration. On the persuasion and advice of the commission, 97-98, party finally amended its constitution to do away with the position of Uddhav Thackeray as Shiv Sena Pramukh for life or till he so desires, and with the provisions for nomination of office bearers solely by the Shiv Sena Pramukh. Removal of such clauses allowed the commission to take that amended constitution of Shiv Sena on record. The decision of the commission both in 89 and thereafter in 97 was in the genre of ongoing and continuous attempts of ECI to mainstream the pre-existing political parties into the framework of newly introduced 29A. In this context, it's relevant to consider that on 16/7/98, the commission directed Chief Electoral Officer Maharashtra to communicate to Shiv Sena and observation of ECI that in a nutshell, the party constitution envisages the president nominating the electoral college, that it is to elect him. This goes against the spirit of democracy and negates the very purpose for which the entire exercise was carried out. In their reply on 29/4, Shiv Sena inter alia made the following specific points. In fact, The Electoral College consists of not only of representatives elected by the ordinary members of the party, but also people's representatives, that is, Shiv Sena members of Parliament and members of the Legislative Assembly and the Legislative Council. Thus, the Pratinidhi Sabha is a body with much broader base in a true sense. Commission has always maintained that political parties, being vehicles of different ideologies, must chalk out for themselves their own manner of functioning and embody the same in their constitution, and all that the Commission insisted is that persons who act or speak on behalf of the recognized political parties should be elected members of the party, and this should be explicitly put in the party's constitution. During the dispute, both sides had referred to a further amended constitution of 2018. The original amendment was 2013, 2013, then 2018, which is not on record of the Commission. In this context, it is critical to refer to conditions of registration of Shiv Sena Party as communicated to the Election Commission on order dated 19/10/89, inter alia, stipulating in para 2 the statutory requirement under 29A as provided in the Representation of People's Act. The party shall communicate to the Commission without delay any change in its name, head office bearers, or any other material matter. Further, the guidelines of the ECI, now note that, these guidelines came into effect in 2010. Exercise of powers conferred under Article 324 and 29A of the Representation of People's Act specifically provide that each constitution carries a clause for amending the constitution, which of course it was in our constitution, both 99 and this one. The applicant party must submit authenticated proof to show that the party constitution has been adopted by the general body. The applicant party must ensure in this constitution itself, via a specific clause in the party constitution, that any amendment to the party constitution must be approved by the general body. I'm just making a comment here, just note it. How is this part of the 15 dispute? How is all this part of a para 15 dispute? Para 15 assumes that you have been elected or nominated under a particular party constitution, and that there is a split in that original political party. Which rival faction is the party is to be decided. What is the dispute of the democratic or undemocratic constitutions got to do with paragraph 15? It's wholly alien, wholly irrelevant. It is only a tribunal, Maras. It can't decide the party democratic or undemocratic nature of party constitution. And I'll assume, Maras, I'll assume for the moment that my party is constitution undemocratic. But your Lordship asked me two questions. What is your defense in law, and how do you prove that your party was democratic in fact? And I'm going to answer both, Malas. But I'll assume for a moment that this is an undemocratic constitution. So what's the consequences? Deregistration. There's no other power.
Not to give the party symbol to them.
But it doesn't allow the party symbol to go to them. He is the creature of the same constitution. How does he get the party symbol? One, it's alien to 15. Two, the benefit can't go to him. And three, what power does the commission have to decide this issue? Assuming it has that power and declares me undemocratic, what is the consequence of that? Is a notice to me to deregister. Nothing more. 29A doesn't give him that power. Now, let us kindly have a look at 20. I'll just pause for a minute. Go to 29A of the Representation of Peoples. Yes, there's a statute compilation also, Madan. We can hand over. Just give it to my lord. We actually have a statute compilation. Easy for your lordship. Give it to my lord. Give me also.
Section 59 of.
Madan, I'm giving your lordships a whole compilation of all the statutes so that, Madan, it's easier for your lordship. 1951 RP Act, Madan.
It's at page 9.
It's page 9, Madan, of the compilation. Just give me a minute, Madan.
59 is special provision in the case of second election.
Yes, kindly now see, it's very important. Any association or body of individuals, individual citizens of India, calling itself a political party and intending to avail itself of the provisions of this part, shall make an application to the Commission for its registration as a political party. Let me tell your lordship the background. Prior to 29A being incorporated, there was only the symbols order. And under the symbols order, you had to apply, the political party had to apply to get a symbol. So when the issue of 29A was debated in Parliament, several contentions were raised. Why do you need this? Because ultimately it is for the symbol. And under the symbols order, you will get a symbol when you apply. You don't need registration. Why are you regulating a political party? Because political party is a voluntary organization. So why should you regulate a voluntary organization? And therefore, there was a very heated debate this forward. And the debate said that, look, you should not force a registration of a political party. It's a voluntary organization. But the logic was that every party must take an oath to the Constitution of India. They said we can't have a political outfit whose objectives are inconsistent with our basic values under the Constitution. And therefore, registration is necessary. That's right. That was the core reason why 29A was put in. Now, if you read 29A, you will find that there. So every such application shall be made if the association or body is in existence at the commencement of the Representation of People's Act, because this was amended in later, within 60 days next following such commencement. So if you have a political party and have a symbol, then you must make this application. If the association or body is formed after such commencement, within 30 days next following the date of its formation. Every application under subsection 1 shall be signed by the Chief Executive Officer of the association or body, whether such Chief Executive Officer is known as Secretary or by any other designation, and presented to the Secretary to the Commission or sent to such Secretary by a registered post. Every such application contains the following particulars. Note that, Mullahs. The name of the association or body, the state in which its head office is situated, the address to which letters and other communications meant for it should be sent, the names of its president, secretary, treasurer, and other office bearers, the numerical strength of its members, and if there are categories of its members, the numerical strength of each category, whether it has any local limits, if so, at what levels, whether it is represented by any member or members of either House of Parliament or of any state legislature, if so, the number of such member or members. The application under subsection 1 shall be accompanied by a copy of the memorandum or rules and regulations of the association or body, by whatever name called, and such memorandum or rules and regulations shall contain a specific provision that the association or body shall bear true faith and allegiance to the Constitution of India as by law established, and to the principles of socialism, secularism, and democracy, and would uphold the sovereignty, unity, and integrity of India. This was the core reason why registration became necessary. This was the only reason for 29A. There's nothing into here to state that you will decide on whether it is democratic or undemocratic. It is completely alien. Now, the Commission may call for such other particulars as it may deem fit from the association or body. Right? So the Commission has the right to ask for other particulars.
At the time of registration.
And that's at the time of registration, no, not later. Then see, after considering all the particulars, as aforesaid in its possession, and any other necessary and relevant factors, and after giving the representatives of the association or body reasonable opportunity of being heard, the Commission shall decide either to register the association or body as a political party for the purpose of this part, or not to register it, and the Commission shall communicate its decision to the association or body, provided that no association or body shall be registered as a political party under this subsection unless the memorandum or rules and regulations of such association or body conform to the provisions of subsection 5. The decision of the Commission shall be final. And then 9 says, after an association or body has been registered as a political party. Now there's a rationale for 9. As aforesaid, any change in its name, that is 29(4), head of office bearers, address, or in any other material matters shall be communicated to the Commission without delay. Now, I ask myself this question, where is the occasion for the Commission to decide under 29A? That's not its statutory power.
Amendment to the party constitution will not be included in any other material.
It's been clarified by Shankaranand in the debate itself. Those other particulars must relate back. There's not some omnibus clause that you can ask for anything, or that there's a duty.
No, amendment to the party, original party constitution, will it not come within any other material matter?
Maharaj, this is the point that has not been clarified. This question was asked in the debates, and I'll show your lordship that debate. He said, don't please interpret any other particulars in this fashion. Maharaj, I'll tell your lordship the rationale for it. What's the rationale is that you must adhere to the principles and other facts, Maharaj. That's all that is required. Maharaj, I've been in this business for more than 35 years now, Maharaj. Kindly see, I appoint a the secretary to the organization? Has he to be elected? I take a decision in the working committee that you people go ahead and execute this. As that person who is the Youth Congress president, is he to be elected? I'll run my party. It's the way I want it. And whereas those who do not want to be part of it can say, I don't want to join your party. You say you'll join my party. You will take the benefits of everything that's happened after joining my party, and then you say everything was undemocratic. I can understand the Election Commission getting to know something egregious that has happened. I can understand that. Normal is what happened. Now, there is no change in the statute. But in 2010, there were guidelines framed by the commission. Framed by the commission, not part of the statute, which required at the time of registration. Now, let's kindly have a look at so that your lordship is clear on the it's part of the compilation. The statute compilation. Doesn't matter, I'll tell you. Right. Mothers, 48. 48, mothers. Guidelines. You also see that? Now just note here. Guidelines prescribed by the Election Commission in exercise of powers under 324 and section 29A. Right? So also have that?
Yes.
And your lordships will note that this was incorporated in 2010 for the purpose of registration. Now just point out. For the purpose of registration of any association or body of individuals of citizens as a political party, the association or body is required to make an application, format Annexure 1. So much parties that have been registered earlier don't have to apply under the guidelines, right? To the Election Commission of India, giving therein full particulars required under subsection 4 of section 29A of the representation. Subsection 4 is those mothers, president of the party and all those things, office bearers. And additional particulars required under the registration of political parties, furnishing of additional particulars order 1992 separately. The application should be neatly typed on the party's letterhead, if any, and it should be sent by registered post, presented personally to the Secretary to the Election Commission within 30 days following. The 30 days applies to a new registration. The old one has had 60 days. Following the date of the formation of the party, any application made after the said period will be time barred under the provisions of 29(2)(b), A2B of the Representation People's Act. All pages of the application, and including annexure, should be numbered in continuation. Then the application must be accompanied by the following documents: party constitution drawn on the following lines. Name of the party, objectives of the party should be in consonance with the constitution, membership of the party, organs of the party organization structure, powers and functions of each of these organizations, decision-making power should reflect democratic spirit, no veto power, and method of appointment and terms of members to each of these organs. Not more than 1/3 member can be nominated. Tenure should be fixed, not exceeding 5 years. Periodic elections within 5 years maximum. Office bearers of the party, powers and functions of each of these office bearers. Decision-making power should reflect democratic spirit. No veto power. Method of appointment and terms of each of those office bearers should be elected. Not more than 1/3 can be nominated. Fixed tenure not exceeding 5 years for everyone. Periodic elections. Then rules of dispute resolution, basic rules of conduct of business, decision-making process, meetings, quorum, notice, decision-making. Details can be annexed separately. Party funds and accounts. And then party constitutions amendment procedure, merger, split, dissolution procedure, and that's the adherence to the constitution. With clear answer against each item therein may be submitted with application number 3(2). The relevant page number of application where the details of the particulars, term and checklist can be verified must be indicated. Demand draft such and such. So, Maharaj, these are guidelines. I'll come to that a little later. These are guidelines which are incorporated in 2010. Admittedly, at no point in time, anybody was issued a notice, right? That you please tell us. But in that dispute, number 1 of 1994, which the Election Commission relies upon, is Sessions' judgment with us, where he says there is no party in this country which adheres to any of this. He says, I am fed up because people don't have elections for years. What's the remedy? He says, remedy is, I will deregister you. That's not an issue here.
Please come to page 50, clause 6.
Page 50.
Please read it.
Yes. Clause 6. Besides these particular procedures to be followed in case of merger, dissolution of the association, amendment party, and disciplinary action against
Party constitution.
and disciplinary
Action.
correct against erring members of the party should be provided in the bylaws. There should be clear provision in the party constitution about membership. There should not be any discrimination. Correct. We've adhered to, nobody disputes any of this.
Contemplates any amendment to the constitution.
Yes, sir, that is there. That nobody disputes that there is no amendment provision.
That will be Article 9 of the application, page 49.
Yes, correct, absolutely right. So that's there, nobody disputes any of that. So, Maharaj, if now you are registering after 2010, all this is to be provided, right, Maharaj? And our constitution provides it, there is no issue in any of this. And I will show to your lordship that each of the bodies which take policy decisions, which are the highest executive, are elected, including the Paksh Pramukh. I'll demonstrate because your lordship said, Sharon, I'll show you on facts. Not that I think the jurisdiction, there is no jurisdiction with the commission to deal with any of this, but they are elected. The Karyakarani out of 13 members, 9 are elected. The deputy leaders are elected. People who are not elected are those who are the executing agencies. Maharaj, for example, I have a district president, Maharaj. I know something about the Congress party. We have district presidents, Maharaj. District presidents are not elected. They're nominated. District president has no policy role to play, Maharaj. He implements the policy of the party. In fact, elections results in, according to me, great disservice to the party because then money power comes in. One group supports a candidate, whereas in fact it causes great confusion and dissatisfaction within the party.
But nomination can be anti-democracy also.
I'm sorry?
But nominating the office bearers can be anti-democracy also.
No, but I have to run my party, Manoj. I know how best to run it. I'm not disputing what my lord is saying. But let everything be democratic, it's fine.
District level is a grassroots democracy.
True, but he is to only implement. He says, "Wahan jaake dharma karo, do this, do that." You don't need elections for that. He doesn't frame policy, Mother. So I can understand that. Highest level of the executive decision-making body should be democratic. And it's democratic. But for example, PCC's mothers are not elected. In Congress, we have a youth president who is elected. But the youth president under the youth organization will have several people who are appointed. So, Maharaj, we need to decide for ourselves what should be our organizational structure, at what level. But, Maharaj, how is this an issue before the commission is the question that we ask.
But always this depends upon the party's constitutional structure.
That's right. And different parties will have different structure. So, Maharaj, how is this? It is what the...
He's an appointee.
Mhm.
He's an appointee of the
Who?
Shinde is an appointee that are democratic. Yes, sir.
Himself.
Very anti-democratic.
And Maharaj, I can understand the election commission if there is a live dispute, Maharaj. He just looks at bare features of the constitution, says it's authoritarian, so I will not look at it. Therefore, I will not look at the organizational structure. We're not doing an academic exercise, Maharaj. So, Maharaj, I'm sorry, I wanted to show this to your lordship to show, and this is not part of the statute, does not say that it will result in not looking at the constitution.
Exercise of constitutional powers supplementing the statute.
That's
It
correct.
will have the force of law.
Whether it has the force of law or not, Maharaj, if it is violated anyway,
Deciding it because this question has not arisen.
that's, and you, if it,
Deciding it.
and besides, even if it has the force of law, you have to give me a notice. Maharaj, kindly see.
Very recently, we have held that there is a jurisdiction in the election under 320.
I've seen that.
This is an order.
That's
under
right.
320.
I mean, judgments are to the contrary. I can only tell your lordship. So, but judgment so far only say 324 can't be used to interpret 29A in this fashion. Every judgment says the same. But leave that aside. We're not concerned with that.
Deciding on the validity of the guidelines.
That's right.
These
Follow your
guidelines are basically meant to give effect to 29A.
Yes.
Child registry.
That's correct.
That's all.
That's all.
we follow your submission that they are prospective in operation.
Yes.
They do not challenge the already registered recognized
But assume as they do, then a notice has to be given to me.
for the record.
Right. You can't decide it in a decision, say it's undemocratic. What is undemocratic? You have to give me a notice. There has to be a hearing. Then you have to hold it's undemocratic. Then you have to tell me, amend it. If you don't amend it, I'll issue notice for deregistration. That procedure has to be followed. How can you
It's
decide?
not even an issue.
It's not even an issue. And well, just one thing, I want to raise a constitutional issue, not raised anywhere. See Article 19, Marat, right to association, for a minute, and I will look at it. This also is a neat issue. I have it. I'm talking about the Constitution of India. So I have it. Okay, sorry. Take 19. That's also interesting. One day it may be. Your lordships may have to decide it. So 19 says, C says, to form associations, So this is, the voluntary organization is an association. I have a fundamental right. Now, what are, the prohibitions? Kindly come to subclause 4. Nothing in subclause C of the said clause shall affect the operation of any existing law insofar as it imposes or prevents the state from making any law imposing in the interest of the sovereignty and integrity of India or public order reasonable restrictions on the exercise of the right conferred by the subclause. So the two inhibitions under 19C relate only to the sovereignty and integrity of India and public order. So I'm sorry, Malaj, if there's a requirement of elections, well, I'm sorry, it's outside of 19. But I'm not going to argue that because it doesn't arise. And therefore, Malaj, in several decisions in cooperative societies and other matters, Malaj, your lordships have held once there's an organization and there are rules and you abide by the rules.
Restrictions.
I'm sorry?
Reasonable restrictions.
Yes, on this basis. Reasonable restrictions only related to these two.
This clause.
Malaj, not beyond it.
On the exercise of the right conferred by the said subclause.
Yes.
Subclause is right to form.
Associations. Under what? In the interest of sovereignty or integrity and public order or morality. Reasonable restrictions. 3 elements. Sovereignty, integrity, public order, morality. Therefore, in several of those association decisions you have said, well, associations should run by their own rules. You don't want to be part of it, you move out of it. So I'm just saying, Malaj, it doesn't arise for you.
Very arguable and debatable area again.
That's right. I'm not.
Reasonable, what reasonable?
Yeah.
Is a restriction on restriction.
That's right.
But the order, public order and morality are very wide words.
Yeah, but I'm sure the Malaj.
So defined time and again.
Yeah. I'm just flagging it.
New principles keep on evolving.
Yes.
So therefore, the expressions also are quite flexible.
I agree, Malaj. I'm just saying, Malaj, this is an issue. To say that it is autocratic, you're autocratic, you can't have such a constitution without a list, without a notice.
Accessible also will be argued this in a different manner also.
We will have to read whether morality is constitutional morality or not.
Social morality.
If you talk of public morality, you can be benevolently autocratic. You can be a benevolent.
Well, in
monarch.
fact, there was
But
very.
when you talk of constitutional morality, they don't coexist.
I agree. Well, there are very interesting debates that go on. Well, they say, you say I have to adhere to socialism, but I don't believe in socialism. Right? My policy is not socialism. Why should I adhere to it?
Socialism in Indian context
It means anything.
is a jacket which fits all.
That's right.
Everyone is
Socialist. Everybody is democratic, Malaj. Concepts that ultimately lead us nowhere. Anyway, I'll come back, Malaj, to where were we?
So we are at page 7.
But your moot point is this. You were already a recognized party. The guidelines could not have been made applicable to you in the absence of a notice given for derecognition.
That's right.
And that cannot be the criteria for rejection of the constitution in which both the groups had
Acted upon
officers
Under this very
the hierarchy.
constitution. Yeah, correct. And it is not part of para 15. Well, let's forget all that. How is this part of a para 15 dispute?
rival factions of the party.
How is that para 15 dispute? So therefore, the adjudication was.
What he was trying to say is the test of majority as per party constitution. Because this party constitution is not available to me, I am not applying the test of majority.
Now, that party constitution need not be available to him under 29. Because if you look at 29(9), it only says change of office bearers. Other material there's no mandate that every time the constitution is amended and I appoint some other person as a secretary, I must give him the constitution.
It becomes material, Mr. Sipal, the office bearers, if the number of office bearers are reduced
Yes,
by an amendment.
yes,
Right?
yes,
Earlier you had given 3 office bearers. now
Correct.
Give 2 office bearers.
correct.
For greater clarity, the amendment should also accompany the name of the office bearers for the.
That's done.
To understand.
That is-
why this time only.
That
2
is
office-
done, Malaj. I
There's a
showed
letter
you.
given with regard to that as per 2018 constitution, we are doing this.
Yes.
These are the persons who become, we forget the particular descriptions of the offices.
Exactly.
But the offices are described, the names of the office bearers are given.
Yes.
What the commission says that this was just a letter reference to an amendment, but the real, actual amendments were not placed on the file.
I agree, Mullahs, but they are not required to be, is the point I made.
That's your argument.
This is not required. Where is it in the 29A that you must give the, we gave the amendments. We gave the name of office bearers. Where do you need to say that the new constitution as amended should be placed before you? It doesn't say, there's no requirement. And they never asked me that, Mullahs. Mullahs,
Mentioned in the guidelines then. Why is it mentioned as a part of the guidelines also? Even for amendment also.
New provision for amendment in the constitution.
at the time of registration.